Mark, Seohyung and I will be giving a brief overview of some of the most recent developments in the High Court in relation to claims against directors of insolvent companies. It is a massively broad topic, and you could spend certainly longer than the 45 minutes we have together to cover any one of the points that we're covering, or indeed many others. And this is not intended to be an exhaustive review of all the causes of action that might be available, whether under the Insolvency Act or otherwise. But what we will be covering, and hopefully refreshing your memories about or teaching you something small that you don't already know, will be the current status of directors' duties, in particular in the insolvency context, in light of the Supreme Court's decision in Sequana, because of course, as we now know, the duties of directors change in certain circumstances. That also ties in with some aspects of claims under Section 1990A of FISMA, where Seohyung, who's also talking on Sequana, will be explaining how that may provide an alternative route through for claims against directors. Mark will then be addressing you on equitable claims against directors, whether proprietary or otherwise, including reviewing the recent Supreme Court decision in Byers and exactly what is required if you're going to bring an equitable claim in respect of breaches of directors' duties. And I will be then rounding up definitely the graveyard slot within the graveyard slot for me, and I'll be covering Section 423 of the Insolvency Act, which strictly speaking is neither is a cause of action neither limited to insolvency nor indeed to claims against directors, but it's an interesting area and has been a fertile area for litigation in recent years as it's become a more prominent tool, and as many of you will know, arises in the context where alleged wrongdoers or debtors are transferring assets away from themselves to third parties, and where claimants or creditors are trying to unwind those transactions to ensure that the claims they have can appropriately be enforced. So I'll be covering that with a very brief review at the very end of a recent substantial piece of litigation I was involved with, which brought together all three of these different aspects, namely breaches of directors' duties, albeit in the case I'll be discussing it was under Kazakh law, equitable claims to follow property, and also Section 423. So without further ado, I'll pass you over to Seohyung, who will be addressing you on the core features of claims against directors and directors' duties in the insolvency context.
When we talk about claims against directors of insolvent companies, it's important to be clear, firstly, who the prospective claimants are, and secondly, which of the duty owed to these potential claimants are alleged to have been breached. Because these two things need to be joined up for a proper claim to be brought against the directors. Whether it's the company via its insolvency practitioners, or some or all of the shareholders bringing the claim against the directors is relevant because the duties the directors owe to the company are different in nature from the duties that the directors owe to any individual shareholder or even to the shareholders as a group. So before thinking about how the various duties or breach of them can add up to a claim, it's sensible to start with a brief summary of what the core directors' duties are. The core duties that the directors owe to the company were codified by Section 171 to 177 of the Companies Act. The ones you're most likely to come across are a duty to promote the success of the company for the benefit of its members as a whole, Section 172. This usually means in the interest of the shareholders, although we'll touch on this when discussing Sequana. A duty to exercise independent judgment, Section 173. And a duty to exercise reasonable care, skill, and diligence, Section 174, rather like the duty of care and tort imposed on other professional people. Allied to these broad responsibilities is a specific record and accounting keeping duty, which requires directors to ensure that a company maintains adequate accounting records and prepare financial statements, which give a true and fair view of the company's affairs. That's Section 386 and 339 of the Companies Act. Against the duties that the directors owe to the company, below are the duties the directors owe to others under other statutes. They need to refrain from misfeasance or wrongful trading, as encapsulated by Section 212 and 214 of the Insolvency Act. And they need to refrain from making misrepresentations about the information the company publishes about itself to the shareholders. Now, I won't touch on the pure insolvency measures, such as Section 212 or 214 of the Insolvency Act, but we'll touch briefly on the securities aspect, Section 1998 of FSMA later. At the risk of sounding basic, it's always important to remember that it's the directors of the company who are responsible for running the company. They have to do so in accordance with the company's objects and the constraints upon their powers. They usually make the decisions about how to trade and what to do based on their understanding of the company's financial statements and positions. They're also the party with responsibility for keeping accurate accounts and for safeguarding the company's assets from fraud. And one new development in this regard is the Economic Crime and Corporate Transparency Act 2023, which contains a new corporate criminal offence of failing to prevent fraud, which will render large companies liable for fraud committed by their associates. What effect this particular tool will have in tandem with other things in the arsenal is yet to be seen. Now, when we're talking about creditor's duty, as Dan mentioned, i.e. the duties that the directors owe towards the company's creditors, it seems like this actually cuts across the director's duties under Section 172 to promote the success of the company for the benefit of its members as a whole. But Section 172(3) makes it clear that there is actually a continuum, and it is the evolution of the company's circumstances that will require the directors to consider one group of people in preference to the other. When the company is insolvent, or when it is virtually certain that the company will enter insolvency, it's clear the directors need to consider the interests of the creditors. But what about the grey areas? That's where it's relevant to talk about Sequana, the Supreme Court case. In Sequana, AWA, the company, the one in the middle, had a potential environmental cleanup liability. Before this liability was crystallized, AWA made a dividend payment to its parent company, Sequana, in satisfaction of a debt. When later it turned out that this environmental liability was far greater than expected, BTI, which had taken assignment of AWA's claims, so standing in the shoes of AWA, brought a claim against the directors of AWA for making that dividend to Sequana. Of course, the backdrop to all this is that AWA went insolvent. Sequana also went insolvent, such that the directors were the only pockets on the table, to mix metaphors. The majority of the Supreme Court held that the creditor duty is engaged when the directors know or ought to know that the company is insolvent or bordering on insolvency, or an insolvent liquidation is probable, although on the facts they found that the directors here weren't liable. Some questions remain. On the day AWA distributed the final dividend, AWA had about 3 million euros left in its coffers and an indemnity policy to cover its environmental pollution costs. It was sold that very day, and no provision or disclosure was made in relation to its potential environmental liabilities on its statements. So Sequana walked away with its debt paid and was no longer exposed to any risk that its debt to AWA would have to be used to fund AWA's environmental liabilities. And it was less than a year after these events that it was discovered that those liabilities were significantly greater than the value of the policy AWA had to cover up the cleanup costs. Looking at how Sequana has been applied since, in the first case since Sequana, Mr. Justice Zaccaroli said, one of the unresolved questions from Sequana is whether, in a case where the company was actually insolvent at the relevant time, whether that is sufficient to trigger the creditor duty, irrespective of the director's knowledge of the company's insolvency. The case proceeded on the assumption that some knowledge of insolvency, whether actual or constructive, on the part of the directors was necessary for the creditor duty to arise. And he then held that a disputed liability to HMRC, which was the relevant liability here, did mean that the company was insolvent and the directors knew it to be so. And that's why Benjamin Franklin here, it may be that, as he said, nothing is certain in death, nothing is certain in life except death and taxes. Now, this is going to be a real whistle-stop tour of securities litigation. Securities litigation has been somewhat of an import from the US, but it is a growing area worth paying attention to, although so far there's only been one decided case dealing with the merits. Section 90/90A gives a direct statutory remedy to shareholders for untrue or misleading statements within or omissions from prospectuses, listing particulars, or other information, for example, the annual reports that are published by the company. Section 90A, or Schedule 10A, which is its successor, is of broader relevance because the audience it captures is larger. Excuse me. Not all of the shareholders will have been the original shareholders who saw the prospectus or listing particulars.
I hope it works.
Thank you. It's great to have a silk who has tech skills.
I know my place.
So what's special about Section 90A FSMA? It navigates around the reflective loss principle, i.e. that a shareholder cannot bring a claim against the company for a fall in the value of their shares due to loss suffered by the company, where the company itself has a cause of action against the wrongdoer, such as the directors. It gives you fraud measure of damages because it requires the claimants to prove dishonest conduct on behalf of the relevant persons. This measure of damages was disputed to be applicable in the Tesco litigation, which settled without judgment. But the quantum judgment in the Blockbuster autonomy case is still awaited, and it will shed better light on this. More importantly, for the purposes of this talk, there can be a personal liability against the directors. In autonomy, Hewlett-Packard had bought autonomy for $11 billion, but subsequently wrote the value down by $8.8 billion. In the classical sense, Schedule 10A would have been of limited use because HP had acquired autonomy. So because HP had acquired the issuer, i.e. autonomy, it would be in the position of bringing a claim essentially against itself. And so what they did was use this thing called the dogleg structure, which was a kind of novel strategy, but not that novel if you think about it. What happened was that HP notified autonomy of its claim under Schedule 10A. Autonomy admitted it, and then autonomy brought a claim against the directors, Mr. Lynch and Mr. Hussain, for the loss. So this is a growing area that is worth paying attention to. Now, difficulties of these claims from both perspectives and what you can do. From the claimant side, it's always going to be difficult proving dishonesty. And prospective claimants, especially if they're not the liquidators and without the statutory powers of liquidators to ask for documents from the directors, they may not have enough to get over the hurdle. So they will have to make the most of getting pre-action disclosure or making use of what comes out in parallel regulatory or criminal proceedings, if any are afoot. Proving reliance is also going to be difficult. In the US, they have a fraud on the market theory, which is that all the available information about the company has been priced into the stock price, so a claimant can establish reliance on the basis that it bought the securities at the market price. That's not the case in FSMA securities action, where you'll have to plead and establish reliance by each claimant individually. Furthermore, from a recent decision in World Council in Individuor, representative actions are not allowed. So we have to proceed in the traditional way of multi-party claimants against the defendants. And although this is coming at the end, first and foremost, you need to know that directors have assets to chase after. And D&O insurances frequently have a fraud exception such that you can't dip into the insurer's pockets. So you need to know this before you start spending any real costs. From the other side, if you're acting for the directors, criticisms will be made of them that they're not being transparent. You can provide disclosure of the contemporaneous records, the board minutes, any reports to show that the directors had their eyes open to potential red flags, concerns and questions were raised and answered, considered, detailed and up-to-date financial statements, information was obtained and thought through. And it will be hotly contested what the directors knew or should have known and whose interests the directors ultimately prioritized. And in a way, providing disclosure of these from the outset can be a real show of strength. Coupled with this, you can exploit what will be the claimant's weaknesses in terms of their pleadings. Because they have less information in their hands, their pleadings will be vaguer. And so you can ask for more information in correspondence, in RFIs. And if that's not satisfactory, you can go for a strikeout or a summary judgment. And I've recently acted in a case where we did manage to get strikeout of an £80 million claim. And so they're given another chance to replead, but it means they're starting at zero. They've got no pleading on the table, and it's as if everything that's happened since is wound back, and we'll hopefully get a cost order soon. Again, D&O insurance will be an issue if fraud especially is at stake. So clear communication with the insurers and getting their cooperation will be important to the success of the defense.
Good afternoon, everyone. Next up on our whistle-stop tour, I'm going to speak about equitable claims against directors of insolvent companies, and in particular, claims for knowing receipt and dishonest assistance. These causes of action are going to be particularly relevant in the context of fraud claims against directors of insolvent companies, especially where the director is a solvent party that the client can sue. In the limited time available this afternoon, I'm going to focus on two key areas. First, the importance of the proprietary basis for a claim in knowing receipt following the Supreme Court decision in Byers and Saudi National Bank. And second, how dishonest assistance can be used to hold directors personally liable for assisting the company in breaches of trust or other fiduciary obligations where the company is insolvent and not worth pursuing. And Lord Nichols said this was a topical question even in 1995. And he asked, how can claimants have recourse to equity, an effective solution, when you have a company which is insolvent? And we know the answer is often by seeking relief from others, such as directors, bankers, lawyers, by relying on fiduciary and other equitable obligations. Turning then to knowing receipt. The ingredients of the cause of action you can see on the slide. I'm not going to read them out. This is a claim that usually arises where a trustee or fiduciary transfers property owned by the claimant to a defendant in breach of trust or fiduciary duty, and the defendant learns about that breach before disposing of the property by transfer to a third party or by some other means. And what I want to focus on today is the importance of the claimant having a continuing proprietary interest in the transferred or misappropriated assets when you bring a claim for knowing receipt. And that, to me, is the central point that emerges from the Supreme Court decision in buyers and Saudi National Bank. I'm just going to very briefly go through the facts of buyers to illustrate that point. Buyers was yet another case in the context of the Saud litigation, which began in Cayman as long ago as July 2009. And Saud Investments Company Limited, or SICL, was a Cayman Islands company and the beneficiary of various Cayman Islands trusts, which included shares in 5 Saudi Arabian companies. Those shares were held on trust for SICL by Mr. Al-Sania. And in breach of trust, quite a clear breach of trust, Mr. Al-Sania transferred the shares to Samba, a Saudi Arabian financial institution, to discharge his own debts to Samba. But the glitch was that the governing law of the transfer was Saudi Arabian law, which does not recognize a distinction between legal and beneficial ownership as such. And as a matter of Saudi Arabian law, the effect of the transfer was that SICL had no continuing proprietary interest in the shares. And as a result, its claim for knowing receipt failed. So to me, that's a very stark reminder of the importance of focusing on the proprietary basis for a claim for knowing receipt. And in this quote from Lord Briggs on the slide, there's a lot of complexity potentially, but the key point to remember is that a claim for knowing receipt is ancillary to the company's right to recover its property, which is passed into someone else's hands as a result of a breach of duty owed to the company. And the reason this issue was considered in some detail in buyers was because a director obviously does not hold the assets of the company on trust for the company. Rather, the company obviously has legal title to its own assets. But what the law says is that at the moment of the misapplication of the company property, legal title passes to the transferee, which in our example would be the wrongdoing director or his agent or his nominee. But the equitable beneficial interest remains with the company, and that is sufficient to support a proprietary claim to the property or its traceable proceeds. So the company would have a knowing receipt claim against a director who received the property with notice of misapplication, subject to any overriding of its equitable interest in the meantime. I'm delighted to say I'm not going into overriding of equitable interests at the moment. And instead, I'm just going to stick with the simple point, which is don't lose sight of the proprietary basis of a claim for knowing receipt, whether you're going after a director, defending a director, or pursuing a professional or someone else in another context. So I said it was going to be a whistle-stop tour, and I'm now moving on swiftly to dishonest assistance, which in practice is a very significant cause of action for the fraud litigator, and sometimes as well in the context, obviously, of third-party claims against directors. Again, I've put the core elements of the claim in dishonest assistance on the slide, and these were encapsulated by Lord Nichols in Royal Brunei and Tan, where he held that there was a liability in equity to make good resulting loss which attaches to a person who dishonestly procures or assists in a breach of trust or fiduciary obligation. The liability of a dishonest assister is ancillary or secondary, and then it only arises where there has been a breach of trust or fiduciary duty by another. But it's a really interesting cause of action in this context because it effectively allows you to make a director of a company personally liable for the default of the company, and in a sense you're therefore avoiding the corporate veil even if you are not piercing it. But obviously, provided you have the other elements of the cause of action, you have the company in a position of being a trustee or a fiduciary and in breach of its duties, and you also have critically, the requisite knowledge on the part of the director. And that is the next stop in the whistle stop 2. I was slightly running out of steam with the slides by this point, so apologies. But I just wanted to touch briefly on 2 of the leading cases on dishonest assistance, particularly because their facts are relevant in this context. First, Rob and I and Tan have mentioned a lot, but the actual facts were just that a director caused monies held by the company as trustee to be used for the company's own business purposes. It's quite a clear breach. He was held liable for dishonest assistance because he caused or permitted the company to apply the money in a way which he knew was not authorised by the trust of which the company was trustee. Next, moving swiftly on, Barlow Close and Eurotrust International. And in case you're wondering, or weren't alive at the time, it was Mr. Clowes who was pictured on the earlier slide, looking somewhat unimpressed, supposedly quite famous at the time, but he used a Gibraltar company to operate a fraudulent offshore investment scheme, which had attracted around 140 million of investment from mainly small UK investors. The scheme collapsed, the company went into liquidation, and Mr. Clowes was convicted of fraud and imprisoned. Found out in researching this on The Guardian, many people up in arms about his 10-year sentence and so on, but not really got any more detail on that. Going back to this, some of the investors' funds had been paid through bank accounts maintained by companies in the Isle of Man by Eurotrust, whose principal directors were the second and third defendants in the claim. And the Deemster in the Isle of Man held that the Eurotrust directors were liable for dishonestly assisting in the misappropriation of the investors' funds. And the appeal to the Privy Council was all about the meaning of dishonesty in this context. You may well be very familiar with it. And it was held that the defendant's knowledge of the transaction has to be such as to render his participation contrary to normally acceptable standards of honest conduct, and it does not require that the defendant should have reflected upon what those normally acceptable standards were. Although obviously if you can prove subjective dishonesty, it's not going to hurt. And on a related note, ignorance is no defence. So if you have a director of an insolvent company who, knowing it to be insolvent, causes the company to pay away its funds to certain creditors in order to frustrate the claim of a person for whom the company had agreed to hold funds on trust, he will or she will have acted dishonestly even if he or she did not know, for example, that doing so contravened the rules on preferences. And the authority for that is Starglade Properties and Nash, which is from 2010, quite an interesting case. But on with the whistle stop tour, and you thought I was running out of steam on the slides before, and this is the same image, so apologies. But I just wanted to say a brief word about attribution in this context, which is another interesting but obviously very complex topic. It's well established, we all know, that a company can have a claim for dishonest assistance against its directors, and the conduct of the directors cannot be attributed to the company as a defence. And the authority for that is Bilter and Nazir. That's what we tend to call a redress case, where a company is seeking to make its own director accountable for the loss the company has suffered as a result of the director's breach of duty. And obviously, it would be absurd, unjust, if a director could rely on his own fault in that context to defeat the claim. It might obviously be different if you're bringing a claim against a company seeking to rely on the fault of the director, or even if you're trying to run, say, a security of action defence based on the fault of the director attributed to the company. I've found that out in a long-running case in the Isle of Man, but I'm going to leave the war stories to Dan. But what emerged from Bilter, and was confirmed in singularis was that the answer to any question of whether to attribute the knowledge of the fraudulent director to the company is always found in the consideration of the context and the purpose for which attribution is relevant. So, summing up, the two main points that I've sought to bring out today, whether you're bringing or defending claims against directors, is first, for a knowing receipt claim, you need to show you have a subsisting, equitable, proprietary interest in the assets which are the subject of the claim. And second, for a dishonest assistance claim, you need to show the director was dishonest by ordinary standards if you're going to succeed, but that might allow you to avoid, if not pierce, the corporate veil. And I think both points are quite well summed up in the quote by Mr. Justice Millett, as he then was in Agip and Jackson, which was long before the decision in Byers, where he said that tracing claims and cases of knowing receipt are both concerned with rights of priority in relation to property taken by a legal owner for his own benefit, whereas cases of knowing assistance are concerned with furtherance of fraud. I'm going to hand back over to Dan now. Thank you.
Thank you, Seohyung and Mark. I will round up with a different topic, a different legal area, which is Section 423 of the Insolvency Act. And this is a really important tool that both claimants and defendants in this space need to be aware of. With breaches of duties by directors, and in particular breaches involving the misappropriation of company funds, frequently the director will not hold on to the misappropriated assets. That may be because they're consciously trying to shelter them from claims, or it may be because they are trying to make provision for their family or otherwise to deploy the assets to some productive use. Now, you may be able to bring a proprietary claim in those circumstances, but as Mark has explained, there will be situations where even where you are talking about misappropriated company assets, you are actually barred from pursuing a proprietary claim. And the Byers case in the Supreme Court, one might have thought, might have given lots of fraudulent directors the idea of giving effect to their proposed transaction by setting up a Saudi Arabian law transfer, thereby immediately extinguishing the equitable interest and precluding a tracing claim. But you would still be able to pursue your Section 423 claim even without a proprietary base. And also there will be cases where the directors are moving assets that didn't belong to the company, that are not misappropriated at all, but where they are trying to effectively make themselves judgment-proof by moving their assets away from themselves in anticipation of possible claims. And again, that is an area where Section 43 is going to be highly relevant. And so what this is about casting the net more widely than merely the director themselves, whether at an injunctive stage, pre-action, during the proceedings, during the underlying proceedings, if you discover these transfers during those proceedings, or at the enforcement stage afterwards. Now, Section 423, some key headline points here. First of all, as I mentioned, I think I mentioned at the start, it's not limited to use in insolvency contexts. It is available in the insolvency context if you are dealing with an insolvent debtor. For example, if the director that you're thinking of suing or that you're representing is now insolvent, a 423 claim can only be brought by the director's trustee in bankruptcy. But it is also a claim that is available in any other scenario. And in that regard, it is just a historical accident that this provision features in the Insolvency Act. Actually, most of the cases that I see arise outside of a strict insolvency scenario, possibly a situation where there may be solvency issues or where your main wrongdoer may not be good for the money, but outside of a situation where there is a formal insolvency. Any victim of the transfer, because we're dealing here with a transfer from debtor or wrongdoer to a third party, any victim of that transaction can bring a claim. Here, in the particular context we're dealing with today, we're talking about possibly an insolvent company that considers the director has breached their duties and is intending to, or is actually pursuing a claim against the director, or maybe has succeeded in a claim against the director and has realised that the director has been putting assets beyond its reach and wants to unwind that. As I mentioned earlier, this does not require a proprietary base. You do not need to establish that these assets, now in the hands of third parties, were originally the claimants. And it also has cross-border reach. And I'll come back to that. Now, the key requirements, briefly, and one point that's not on the slide, who is this claim being made against? If you are considering pursuing such a claim, or if you're instructed to defend one, you are suing the person who now holds the asset which you are seeking to get your hands on if you're a claimant. So the appropriate main defendant is the person who has title to the asset. Now, you may well join your wrongdoer, your transferor, the person who's moved the asset to the third party. If you want them to be bound or for some other reason, it may well be appropriate for that person to be a party also. And in addition, in my experience, often you are bringing these 43 claims in proceedings where, if you're a claimant, you are already suing the wrongdoer. So your main wrongdoer may already be a defendant in their own right. But you will need to join, if you're a claimant, the person with title. And if you're acting for a defendant, and if they haven't identified the defendant correctly, then that obviously will be a point you want to bear in mind. Beyond that, the core requirements are that the transaction be for no consideration or at undervalue. So that will include gifts, settlements of property into trust for no value or undervalue, any other transfer other than at market value. Then we have the question of purpose. The statute refers to the purpose as needing to be to put assets beyond the reach of creditors. Now, an important point here, which has been litigated but now is certainly resolved, is that there is no requirement to establish that the purpose of the transfer was, or that the sole or dominant purpose of the transfer was to put assets beyond the reach of creditors. It need only be a purpose. And what the Court of Appeal said in the Hashmi case, which I've mentioned on the slide, is that it will be commonplace for there to be two purposes in parallel, one being to put the asset beyond the reach of the prospective claimant, but also there being a collateral purpose, which is, for example, to provide for your family if the transfer is, for example, to a spouse or to a child or into a family trust or something similar. So the fact that the transferor may turn around and say, but I was doing this to provide for my family. I was transferring this valuable property into the names of my children to make a gift to them, to provide for their long-term well-being, will not be a defence if the court is prepared to find that another purpose consistent with that was to put the asset beyond the reach of creditors. One final point here. The purpose of the transferor to put the asset beyond the reach of creditors, it does not need to be their purpose to put it beyond the reach of the specific claimant who is now bringing the claim. As long as they are intending to put the asset beyond the reach of creditors generally or a creditor, it does not matter if they did not have the particular claimant in mind. Now, finally, I've mentioned there as a third point that the claim can be made, by a victim. Now, assuming that the debtor is not insolvent, the definition of victim is broad. In the Act, it is a person who is making or may at some time make a claim. And the case law has made it clear that it is to be interpreted widely. And so any person, company, creditor, claimant who is prejudiced by the fact that the wrongdoer or alleged wrongdoer has moved the asset to a third party can bring a claim. Now, interesting fact, or possibly not, if you are on PowerPoint at 10 o'clock last night trying to find an image for your relief slide, and you look for a stock image within PowerPoint under the word relief, that is what you were offered. So that is what you have been provided with by me. Now, What is the relief available? It is extremely broad. Now, you can unscramble any kind of transaction. I've explained that, I've made the point there on the slide about as to who you are generally seeking relief against. But the final relief is extremely broad. You can unscramble any transaction. A transaction includes what is described in Section 436 of the Insolvency Act as an arrangement. An arrangement can be an understanding between parties, formal or informal, in writing or not in writing. A number of steps in a transaction can be treated as an arrangement, or even a single step can be an arrangement. So you can, if you're acting for a claimant, you can target any one of these aspects. And that's a challenging area for defendants because the legislation consistently, in accordance with the authorities, is to be interpreted widely at pretty much every stage. And by way of example, there was a Russian, very high-value Russian marital dispute, Akhmedov against Akhmedova, which resulted in a substantial judgment for the wife, who then pursued a series of 423 claims, trying to unwind transactions that the husband had entered into. And a particular transaction that she sought to set aside involved a Panamanian company controlled by the husband moving monies from one account to another, and then from the final account, moving the monies into a Liechtenstein trust. And the court was prepared to accept that all of that amounted to a single transaction that should be unwound. And I had a similar situation on a smaller scale when I was a junior in a case called Bataillon against Seohyung, where the court was prepared to accept that the way that you structure your transfer could amount to an arrangement. In this case, again, it was a transfer from husband to wife, but what was being, in order to put the asset beyond the reach of my client, who was a creditor of the husband's, and what was done was rather than a simple arrangement where monies were put into, say, a joint account between husband and wife in England, which would have allowed my client to enforce against the husband's portion, the monies were put into a Panamanian foundation. And initially the judge looked at me and said, well, what's wrong with that? It's still husband and wife property. And I said, well, it's now made it very difficult to enforce against. So it should be unravelled, and the husband and wife should be ordered to restore it to a structure that is capable of being enforced against. I've mentioned here freezing orders. This is a typical case where the court is often prepared to make freezing orders against the third party that now holds the asset under the Shabra jurisdiction. I've made applications of that nature and resisted them. And it's now, in the last 10 years, I would say, a reasonably well-trodden path. So if you have discovered the transfer and are trying and are concerned, and you're for a claimant and you're concerned about onward dissipation, then you can look to get a freezing order against the third party that now holds the asset. Equally, good to know if you're a defendant that that sort of relief is available if you are served with such an order. Now, briefly, the extraterritorial nature of the statute. It is not confined to transactions taking place within the jurisdiction or which are effective within England. It's not the relief is not limited to recipients within the jurisdiction. Now, I should say, just turning back to relief briefly, matters such as whether the recipient is has changed their position may be relevant, but their location will not be relevant. And so if you're seeking permission to serve out on behalf of a claimant, there is now a specific gateway for this, and the Court of Appeals confirmed it's available for Section 423. You will still obviously need to satisfy the court that England is clearly and demonstrably the appropriate place to bring the claim, notwithstanding that the holder of the asset is outside the jurisdiction and the transaction may have taken place outside the jurisdiction. And that marries up with a feature of the case law, which is that the courts will generally not make an order against under 423 unless there is a sufficient connection with England and Wales. So if you are in one of those cross-border cases and if you are for a defendant, this is something you're going to be looking at very carefully. Can the claimant make good their contention, both for jurisdictional purposes, for the purposes of service out, but also for the purposes of substantive relief under the Act? Can the claimant make good the sufficient connection with England and Wales? And the narrowest sort of connection that I've seen being found to be sufficient is where the underlying claim against the wrongdoer is in England, and you are seeking to take steps to enforce your judgment against a third party outside the jurisdiction, and you will say to the court, if you're the claimant, well, I've litigated this in England so far, I've got or I'm about to get an English judgment, therefore the enforcement proceedings should take place here. But that's going to be the thinnest basis possible, and it will be highly fact-sensitive, this. That's a quote really confirming that the courts are prepared to take steps under 43 in foreign cases, but it will be highly fact-sensitive, and questions of foreign law and so on will apply. A brief word on limitation quickly. I've not got a slide on this. Be aware of limitation, whichever side you're on. This is a very nuanced area in Section 43 claims. The current state of the law is that in a decision from Lawrence Rabinowitz, sitting as a deputy judge, if you are trying to recover money, it is 6 years. But if it's trying to recover property in trust, unwind the trust, it's 12 years. There is still a debate about when that limitation period starts running from. Is it from the date of the transaction? Is it the date when you became a victim of the transfer, if you're a claimant? Or is it the date of bankruptcy of the debtor? And there is no settled law on that. And that's obviously a massively important area, because often a claimant will only discover the transfer after the event. But defendants beware, Section 32 of the Limitation Act and deliberate concealment and fraud extensions will apply. Now finally, just a couple of minutes on this case, which really brings together the features of the law that we've been talking about today, and I will keep it brief because I think drinks await outside. But this is the Kazakhstan Kagazi litigation is a very substantial piece of litigation I've been involved in since 2015, and which some parts of which are still ongoing. But to cut a long story short, the claimants are a Kazakh corporate conglomerate that had raised money through flotation on the London Stock Exchange and various substantial bank loans, and seemed to be doing very well. A thriving logistics and recycling business on the face of it had been run by Maksat Arip, photo on the left. Although the eagle-eyed amongst you, possibly you can't see it at the back, someone has stitched on the photo of Mr. Arip with the white cat. We've never seen him with a white cat so far. He was alleged to have conducted a massive fraud on the business by the buyers of the business. He'd sold it to people on the basis it was a thriving business. They looked under the bonnet over the next few years and realised that was not so. Substantial proceedings took place in London. We got a worldwide freezing order at the start, and he disclosed, amongst other assets, 72 million in a Swiss bank account, but held via a Cypriot family trust, and also a very valuable property in West London, also held via a Cypriot family trust. The litigation ran on. We had a 13-week trial in front of Mr. Justice Picken in 2017, and ultimately got a $300 million judgment against him. But zero in recoveries at that stage. And there were injunctions, there were committal proceedings. But eventually, we launched effectively wave 2 of the litigation, which was the enforcement stage. And here, we launched 3 different types of claim within the same proceedings. And this is where it really brings together the different aspects that you've seen. Now, the underlying claims were breaches of directors' duties under Kazakh law. We argued successfully at trial that gave rise to a proprietary base, i.e. we could follow the monies that had been misappropriated from the claimants. And we were able to establish through a lot of sleuthing and some disclosure orders against banks, we were able to trace through from the monies stolen from us into these assets, amongst others. In some cases, it was not at all straightforward, but we managed it just. So we had our tracing claim on the basis that we were able to follow at every stage the interest and the money moving from us into these assets, which were now owned by family trusts. So tracing was the first remedy, having established breach of directors' duties at the original liability trial in front of Pick and J. cause of action 2 was Section 423, because these transfers, we said, had been made to put the assets beyond our reach, very valuable assets put into family trusts, away from Mr. Arip into family trusts in Cyprus, which has a very protective trusts regime, including a 1-year limitation period, which we had to challenge. So Section 423 and the unravelling of these transactions was our first alternative case on the basis that these were gifts to the trusts and had been carried out for the purposes of putting the assets beyond our reach. And then our third claim was a different type of claim, was a claim that although, if contrary to our case, these were true trusts, the beneficiaries were not the family members generally, but the true beneficiary was simply Mr. Arip, and this was a way of concealing his interest. We pursued that to a 4-week trial in front of Mr. Justice Henshaw, where we succeeded. And as a result, we got orders for sale against the West London property, as well as other properties in Mayfair, and eventually managed to get our hands on the 72 million in the Swiss bank account. And it's a useful judgment if you are interested in any of these things, tracing, proprietary claims, Section 423, because it contains a reasonably comprehensive summary of the law on all of these areas. An extraordinary case to be involved in, and ultimately, after a lot of fighting, a happy success story for the claimants in that particular case. Unless anyone has any questions, we're very happy to field questions here or to take them over drinks. I'm assuming that people are probably quite keen to get out for a drink, so I'll probably close it unless anyone has a dying, burning ambition to speak now. And so I'll only, it remains really for me to thank you for coming. Thank you for your attendance all day, and thank you for coming to our talk this afternoon.